I'm Vinnie Politan. Great to have you with us here on Closing Arguments. We're live in downtown Dedham, Massachusetts at the Blue Ribbon Barbecue, covering the trial of Karen Read, accused of murdering her police officer boyfriend, John O'Keefe. There is one big question here for one big piece of potential evidence for prosecutors. A confession. A confession. Like the best direct evidence you could have. The accused admitting what they're accused of. Did Karen Read, in this case, confess to striking John O'Keefe with her car? Well, prosecutors are saying yes. Take a listen.
Several firefighters from the Canton Fire Department you'll hear from in regard to their observations of injuries, abrasions, and lacerations to the right arm of Mr. O'Keefe. You'll hear their testimony in regard to swelling of his eyes and other injuries that they observed redness from the cold that he had been lying out in for some time. And at least from three of those firefighters, you'll hear testimony anticipates detailing statements that the defendant made to them when they had asked about the origination of some of those injuries. The defendant stated repeatedly, I hit him, I hit him, I hit him.
So, are these alleged confessions credible? Are the witnesses who are saying they heard them credible? Will the jury believe them? So, we've had 2 days of this trial so far, so we've had some witnesses on this exact issue. So what we're going to do for you right now is play that testimony and then play the cross-examination of the defense trying to attack the credibility of the statements, the credibility of the witnesses. Let's take a look.
So when I arrived, I saw Miss Read looked like she was giving CPR to him, and she had blood on her face.
After the fire department arrived and they sort of take over resuscitative efforts with regard to Mr. O'Keefe, what, if any, observations did you make of Miss Read and what she was doing or saying at that point?
Miss Read was visibly upset. She kept saying, this is all my fault, this is my fault, I did this. And she was very hysterical. And she kept asking, he's dead, is he dead, is he dead?
And with that specific phraseology, that's something that she kept saying?
Yes.
And by your repetitive nature, I'm assuming it was something that she said more than once, correct?
Several times, correct.
So in April of 2022, for the first time, you attributed the phrase, "This is my fault. I can't believe this happened," to my client, correct?
That's correct.
But nowhere in your official report did you say that, correct?
That's correct.
And nowhere in your interview with Trooper Proctor the next day did you say that.
That's correct.
You think that was a pretty important omission on your part?
It was an oversight.
An oversight?
Yes, sir.
That a woman whom you made contact with, standing over the body of a fallen police officer, said to you, "This is my fault." Just missed that one. Yes?
Yes, I missed it. Yeah, I didn't write it down.
Now, as far as the defendant, Ms. Reed, what, if anything, do you recall her sort of doing as you're on scene and as you're going about what you're trying to do?
She was screaming, is that my boyfriend? Is he dead?
When you say screaming in a fairly loud voice, correct?
Very, very loud, yes.
And as far as that sort of phraseology, as far as is he dead, how many times was that something she said? Once, more than once, or something?
Repeated many times.
You stated that she kept repeating two phrases, one being, "Is he dead?" and the second being, "That's my boyfriend," correct?
Yes.
And how many times do you think that she repeated those two phrases?
It's quite a bit, more than 10.
You got there not long after Officer Saraf, correct?
Correct.
During the time that you were on scene and you heard Karen Read screaming and yelling in this distraught and hysterical manner, you never once heard her say, "I did it," correct?
I did not.
You never once heard her say, "It's my fault," correct?
I did not.
You never once heard her say, I hit him, I hit him, I hit him, correct?
I did not.
If you had heard any of those statements, you would have recognized that those would have been important to note, correct?
Yes, sir.
And you would have noted those in your police report, obviously, correct?
Yes.
As I was ventilating, I was able to ask, did anybody see anything? What happened? And there was one individual that replied several times, I hit him, I hit him.
With reference to that statement of I hit him, is that something that she said once or more than once or something?
It was several times.
And as far as the tone or demeanor, how loudly was this being said?
As previously stated, they seemed to be erratic. There was a lot going on in that scene. It did seem to be said over and over and at varying volumes.
You said, as you're knelt down, do you know him? Directly to the female, and she answered your question with, I hit him, I hit him.
Yes.
But that's not what you told Trooper Proctor in a February 8th interview. Is it?
I don't recall what I told Trooper Proctor.
Do you recall telling Trooper Proctor specifically that while you were rendering aid, you heard Karen say, I hit him, to another female on the scene, and the other female told Karen to be quiet?
I do recall that.
Okay. That's not what you testified to today, though.
Okay.
Matter of fact, that story has changed to you posed a question and she answered your question. Correct?
Correct.
So a firefighter, paramedic, and 2 responding officers. 3 witnesses so far. Is this proof of a confession by Karen Read? Let's bring in our guest joining us. Bill Keefe, criminal defense attorney. We got 2 great experienced attorneys here. And Joseph Krowski Jr. back with us as well. Great to see you guys. Bill, is that a confession?
Admission. It's certainly not a full-blown confession, but certainly a series of admissions to a couple of firefighters, some other first responding police officers. I thought Attorney Jackson and Yannetti did a very good job at pointing out that they hadn't documented the supposed statements attributed to Ms. Read. They've embellished them, perhaps. But yeah, I think it's one of the few problematic areas for the defense in this case.
Okay, so it's a confession. It's slightly less than a confession, an admission. That's what you're saying. Okay,
Yes.
all right.
Love Bill, great lawyer, but I got to disagree. Maintaining my objectivity for the week, brutal start for the Commonwealth with their non-civilian witnesses. An officer shows up at a scene, there's a body that is an individual severely injured, and he purports to hear, I did it, I did it, I did it, and doesn't document that in the report. Now, I know that you don't memorialize everything, but if you know there's a body and it's a life-threatening critical condition, if a police officer hears, I did it, you're going to document that in the report. Second point to that, I know he's not investigated. Not a lot happens in Canton before this case, but I think the defense attorneys did a nice job, but left a little meat on the bone. You did what? What do you mean you did it? Did you hit him?
Right, no follow-up question.
Did you hit him with a car? Because that's their first opportunity. She might clam up after that. Any officer should know to do some follow-up. Does nothing. And he doesn't report it. The other officer, Mullaney, is right there after Saraf, doesn't corroborate hearing the statement, thus doesn't have it documented in his report. Then you got EMS Nuttall. Certainly confident, self-assured, but I've done cases where EMTs, first responders, show up. That asking, what happened? How did it happen? You're trying to get a statement not as an investigator, but to provide medical treatment. Those EMT reports usually document statements of cause of injury. So if you hear, I hit him, I hit him, I hit him, you're going to write that in your EMT report. He doesn't report that until he meets with Proctor. And again, I don't know if Proctor told him to say that.
Right.
That could be suggestibility. He could innocently hear it all the time and now thinks that that's what was said. Massachusetts is a humane practice state. It is an open question. That means this judge is going to tell the jury, not only does the government have to prove the elements of the charges beyond a reasonable doubt, they have to prove Karen Read made those statements beyond a reasonable doubt. It's called the humane practice. Then, even if they conclude she made the statements, they have to be convinced beyond a reasonable doubt she made them voluntarily. And they can assess her mental state, the condition, the circumstances. And on either of those prongs, they can reject those statements outright. But again, just nothing's going in clean yet for the Commonwealth. Look, we're at the beginning moments of the trial, nowhere near the crescendo, but I think it's been a really difficult start. And I'm being objective here, and I also didn't think there was a lot of oxygen in the room.
Does it smell like sloppy police work, which I've seen that allegation in case after case, coast to coast in courtrooms, right? The police never do a good job. They're always walking all over the scene. No investigation has ever been done well, according to every defense attorney in every case I've covered, right? So is that what we're talking about here, sloppy police work? Or are we talking about the next level, which is framing Karen Read, that getting people to say something that they know isn't true?
Now, I don't think Saraf doesn't strike me as the type that's part of any type of conspiracy at all. It's sloppy and it's negligent and it's not
So
his
what does it
fault.
mean?
Canton doesn't have experience responding to this type of crime.
So what does that mean, Bill? What does that mean for this case? And what does it mean for the truth of what happened?
Well, we're going to see whether Karen Read herself testifies, and I think the defense has posited this as her saying, did I hit him? Did I hit him?
Like my cousin Vinny.
Exactly.
I shot the clerk. I shot the clerk instead of I shot the clerk.
And that remains to be seen, but there's more of this coming. There's, I think, the next couple of witnesses. Another firefighter attributes these same statements to her. I think she did document them in a report. So, you know, again.
Well, let me ask you this. Another question. Let's say the jury believes that she said that. Does that equal murder?
No, and the circumstances under which she says it, and you know, there's some evidence here that her level of intoxication, she was blacked out drunk the night before. She tells Kerry Roberts and a couple of people on the ride to 30 View Fairview that she only remembers leaving the bar and does not remember even going to 34 Fairview. So we've seen the dash cam video of her in complete hysterics. So I think...
So that helps the defense.
It does.
It does.
I'm a little surprised they didn't object to those statements at the time they were being offered into evidence to preserve that issue. And I'm not sure if pretrial they held a motion under the voluntariness, because the judge is essentially the gatekeeper before it even gets to the jury.
But does this mean murder? If the jury believes it, does it mean murder?
No.
What does it mean?
With what I've been saying all along, it's evidence that you could add to a charge of motor vehicular manslaughter by OUI if you go down that road, but it certainly
And what
doesn't.
does that mean in terms of
because
prison?
murder, you have to prove in terms of what? Prison?
What's the difference if the jury finds that it's not murder, but it's something else, if they believe she said
Well, motor
that?
vehicular manslaughter by OUI in Massachusetts carries a 5-year minimum mandatory. Involuntary manslaughter has no minimum mandatory. Murder has life, but parole eligible between 15 and 25 years. Difference is, the big distinction here, murder, you've got to prove malice, and malice requires intent to either kill, to grievously injure someone, or intentionally doing an act that you know is going to hurt or kill someone. How are they going to get that intent? And again, it's the byproduct of the overcharge. You saw ADA Lally struggling in his open to try to get there to the intent part of it. You got to lay out some of the information you're opening. And it's not for a lack of trying or a lack of talent on his part. The intent just isn't there for the murder charge. We should be having this fight about whether or not she's guilty or not guilty of motor vehicular charges.
Let me ask you this. I'm going to just ask you for a number. 0 to 10 on this issue so far. 10 being she confessed, 0 being there's nothing there. What is it, 0 to 10? Right now, because we know the trial's just starting.
In consideration of the humane practice, a 3.
What do you have it?
3.
3. Where do you have it,
In
Bill?
the same range, 2 to 3.
That's not good for the. We're in the prosecution case.
It's not good. They can consider intoxication as well on whether that statement was voluntarily made.
And if the jury thinks that she's intoxicated, what does that mean for the charge of murder?
That also can negate malice.
Wow.
That's a mitigating factor.
So,
Vinny, it shouldn't be a murder case.
well, what you're telling me, and it's not about not guilty, but the intoxication helps to fight the murder charge here.
Absolutely. Diminished capacity. It's not an NGI defense, it's a diminished capacity
Wow.
defense. Whether or not Karen Reed, if for the sake of argument they believed struck him intentionally, could form the intent
All right.
that comprises malice.
I told you they were smart. I told you they were experienced, and they're staying. They're in lockdown for the next segment. When we come back, we're going to talk about the defense theory that Karen Reed was framed.
We are underway in the trial of doomsday prophet Chad Daybell.
Prosecutors say they will seek the death penalty against him.
Investigators have recovered human remains at Chad Daybell's residence.
There's no way, Logan. I can never come up with this.
His wife, Lori Vallow Daybell, has already been convicted.
Now, will her husband end up with the same fate?
It's just so hard to know where the truth ends.
It's the doomsday prophet, Chad Daybell, on trial.
Why Karen Reed?
I believe that she's been framed. I believe Officer John O'Keefe entered Boston police officer Brian Albert's home. There was a party, FBI saying at least 13 people in the house. We believe some sort of altercation turned into a melee and involved the homeowner's dog. And I believe that it was a conspiracy and that his body was placed on that front lawn sometime after 2:30 a.m.
Now, this is not a conspiracy theory that's just picked up by some people on social media or people outside of the courthouse. This is the defense case. This is the defense case. And both attorneys, David Yannetti, Alan Jackson, they've been talking about it. They've been arguing about it in pretrial motions over month after month after month. Every appearance we hear different parts of it, and now it's all out there. And David Yannetti he was very clear in his opening statement. I'll play it for you again. You can't miss it. It's the first thing he says.
Karen Reed was framed. Her car never struck John O'Keefe. She did not cause his death. And that means that somebody else did.
So, if she was framed, who was potentially involved in this conspiracy? Because it has to be a conspiracy. It's more than one person who's framing her. And we've heard that in court, and we've heard it in different places. So right now I want to go through a list of potential people involved in this conspiracy to frame Karen Reed for the murder of her boyfriend, John O'Keefe. And it begins with Brian Albert. He's a witness. He's the owner of the home where this after-hours party was. He's a Boston police officer, the owner of the German Shepherd that we've heard allegations part of the attack, maybe caused the scratches on John O'Keefe's arm. And if you listen to Karen Reed, when she's arrested for murder, she names Brian Albert. She names Brian Albert and points the finger at him as being one of the ones who beat up John O'Keefe. Second, Colin Albert, another alleged witness. This is Brian Albert's nephew, who is also identified by Karen Reed in that body cam video when she is arrested for murder. Chris Albert, another possible witness, Brian Albert's brother, Colin Albert's father, and the defense is alleging that he was at this after party where this attack, this ambush took place. Julie Albert, possible witness, wife of Chris Albert, mother of Colin, and the defense alleges that she offered to give the lead investigator in the case, Proctor, a thank you gift. Jennifer McCabe, you're going to hear that name a lot. Another witness, Brian Albert's sister-in-law. She's the one that the defense says made this how long to die in the cold Google search at 2:27 a.m. and was with Karen when they discovered John's body. Michael Proctor, state trooper, lead investigator in the case, never entered the home after O'Keefe's body was found on the yard, alleged by the defense to have lied to the grand jury, alleged to have unlawfully searched Karen Reed's cell phone, is currently under internal investigation. Brian Higgins, another witness, an ATF agent at the office in Canton, with an office at the Canton Police Station, had an alleged romantic entanglement, whatever you want to call it, with Karen Reed, and alleged to have spoken on the phone with Albert at 2:22 a.m. And there's Kevin Albert, brother of Brian Albert, detective with the Canton Police Department, alleged as an intermediary between Brian Albert and Higgins. It continues. Michael Morrissey, the Norfolk County DA, made the unprecedented virtual statement during all of this and under federal investigation. Kenneth Berkowitz, we've heard his name before, the former Canton police chief, allegedly found pieces of the taillight 1 week after the crime. And even the judge, to a certain extent, Beverly Canone, alleged by the defense to have personal ties to the McCabes. So that's a lot of names. Is it a viable argument? Is it a plausible argument? Let's bring back in our guests, Bill Keefe, Joseph Kraske Jr. Bill, I'll give you your first impressions of have you, in your career, ever alleged a cover-up / frame of someone charged with a crime?
No.
No.
And I've never seen anything like this, especially where the FBI has gotten involved and the United States Attorney's Office has initiated a grand jury investigation, and this has gone on for the better part of a year or 18 months, literally half of those names, and the judge is not involved in any kind of conspiracy here, but most of the names on that list you just mentioned have all been subpoenaed and testified before the federal grand jury. So it is truly remarkable. I do think that the focus here is going to be on Trooper Proctor with...
As sort of the leader and the most important member of all this. Yeah. Joseph, your thoughts about...
Where do I start?
Yeah.
Okay, so full disclosure, I'm not a journalist, but it's no secret. I had legally represented and had advised Colin Albert previous to this. We are on good terms, but I don't represent him. He has other counsel. Look, I agree with vigorous defense. I believe if you in good faith have third-party culprit evidence, you need to pursue it. But lives do matter, and you don't want to just throw anything and see what sticks to the wall. What was done to Colin Albert in this case was an absolute, utter disgrace. The kid was a student athlete, went to bed, woke up to people calling him a murderer. Tell me, a year and a half later, give me one single witness that puts Colin Albert within a mile of John O'Keefe that night. Colin Albert, a young man, went to the federal grand jury, did not assert the fifth, went in and was questioned by the feds, gave them every single thing they wanted to know. Colin Albert has data and information showing he left the Fairview Road address at least 15 to 20 minutes before John O'Keefe even got there. Yet people, I hope he rots, I hope he goes to jail. To me, that was disgusting, and you see that they've backed off from Colin Albert. And we can go through the other parties, and again, look, Proctor's fair game, but you gotta have one witness that cracks, right? You gotta have someone that cooperates. People walk around and say, oh, Brian Albert tuned him up. Where's the witness that says Brian Albert assaulted John O'Keefe? They don't have one. So I think they've gone much more obtuse now and much more macro in the conspiracy that something happened in that house and Proctor
pointing
covered
a
up.
specific finger in front of the jury.
Without pointing the finger, but they were throwing people's names around. Chris Albert wasn't at the party when John O'Keefe was there, and they were picketing his business. They were going to his town meetings, holding up signs. I mean, Look, there's got to be, I'm as aggressive as there is, but you got to have some good faith and humanity in how you do this, because there's been a lot of collateral damage inflicted.
So the bottom line, we're out of time for tonight, but the bottom line, you believe the way the trial's going to go, they're not going to get as specific as they were in the pre-trial motions and everything leading up to it, leaving it a little more general that something happened in the house.
Judge Cannone won't, you got to have at least, and it doesn't, even reliable hearsay, but third-party culprit, you've got to establish a foundation to get that
And
in.
they don't have it yet. We'll
They
see
don't
if it
even have
develops.
close
We'll
to
see
it.
if
They
it develops.
promised it, so it's going to be interesting.
Joseph
And the two
Krowski
things
Jr.
aren't mutually exclusive.
Right.
She can be not guilty of murder, and no one in that house had even touched her. That's an unresolved question.
Bill Keefe, great to have you here. Joseph,
Thank you,
great to
Vinny.
see you as well.